What is expropriation? The law of taking. To understand the legal concept of expropriation, it is useful to look at the legal analysis presented by the Supreme Court of Canada in the decision rendered by Supreme Court Justices Cote and Brown in Annapolis Group Inc. versus Halifax Regional Municipality. Justices Cote and Brown provide an overview of the law of takings as it pertains to expropriation through regulation, which they refer to as constructive taking in preference to other commonly applied terms such as de facto or regulatory taking, as in their view it more accurately captured the nature of the state action at issue and the effect on the landowner. A taking is a forcible acquisition by the Crown of privately owned property for public purposes. It may take the form of constructive taking, effective appropriation of private property by a public authority exercising its regulatory powers, or a de jure taking, a formal expropriation by, in the case of land, taking title. To be clear, not every instance of regulating the use of property amounts to constructive taking. Governments and municipalities holding delegated provincial regulatory authority validly regulate land in the public interest without affecting takings, properly understood. The line between a valid regulation and a constructive taking is crossed where the effect of the regulatory activity deprives the claimant of the use and enjoyment of its property in a substantial and unreasonable way, or effectively confiscates the property. Put simply, in order for a Crown measure to effect a constructive taking of property, private rights in the property must be virtually abolished, leaving the plaintiff with no reasonable use of the property. A series of lower court judgments affirmed that, in general, Canadian courts require a total loss of the plaintiff's interest in property for the Crown's actions to constitute a taking. Courts have therefore dismissed claims for compensation where the regulation left the owner some reasonable use for the property. At common law, taking of property by the state must be authorized by law and triggers a presumptive right to compensation which can be displaced only by clear statutory language showing a contrary intention, that is, an intention not to compensate. This was recognized in Attorney General versus the Kaiser Royal Hotel, wherein Lord Atkinson stated, "The recognized rule for the construction of statutes is that, unless the words of the statute clearly so demand, a statute is not to be construed so as to take away the property of a subject without compensation." Explaining the rule's rationale, His Lordship cited to London and North Western Railway Company versus Evans, per Lord Justice Bowen, saying, "The legislature cannot fairly be supposed to intend, in the absence of clear words showing such intention, that one's man's property should be confiscated for the benefit of others, or of the public, without any compensation being provided for him in respect of what is taken compulsorily from him. Parliament and its omnipotence can, of course, override or disregard this ordinary principle, if it sees fit to do so, but it is not likely that it will be found disregarding it without plain expressions of such a purpose." Lord Paramore agreed with Lord Atkinson that this rule was well established and that justice requires that statutes should not be construed to enable the land of a particular individual to be confiscated without payment, absent clear words to the contrary. It is important to stress that the rule contemplates that governments have the power to immunize themselves from liability to pay compensation for a taking, while, as we explain, we do not expand that liability but merely affirm it. The point is that governments may effect takings without paying compensation, so long as the enabling statute clearly expresses that intention. Notably, in CPR, the legislation at issue, the Vancouver Charter, immunizes the city from compensating landowners for any loss as a result of the restrictions on land development and use. From the standpoint of government, the exigencies of the rule are modest and easily satisfied. This court first applied the rule in De Keyser's Royal Hotel in Manitoba Fisheries Limited versus the Queen. Justice Ritchie for the court cited the passage from Lord Radcliffe's speech in Belfast Corporation versus ODR De Cars Limited with approval. On the other hand, there would be the general principle accepted by the legislature and scrupulously defended by the courts that the title to property or the enjoyment of its possession was not to be compulsorily acquired from a subject unless full compensation was afforded in its place. Acquisition of title or possession was taking. Aspects of this principle are found in the rules of statutory interpretation devised by the courts, which required the presence of the most explicit words before an acquisition could be held to be sanctioned by an act of Parliament without full compensation being provided, or imported intention to give compensation and machinery for assessing into the act of Parliament that did not positively exclude it. This vigilance to see that the subject's rights to property were protected, so far as was consistent with the requirements of expropriation of what was previously enjoyed in specie, was regarded as an important guarantee of individual liberty. It would be a mistake to look on it as representing any conflict between the legislature and the courts. The principle was, generally speaking, common to both. That the rule in De Keyser Royal Hotel is one of common law answers Halifax's submission that interpreting the protection narrowly against uncompensated takings avoids creating a common law backdoor to constitutionalizing rights which were excluded deliberately from the Charter. It is, of course, true that the framers of our Constitution did not include the protection of property rights in the Canadian Charter of Rights and Freedoms. But the Charter is not and never has been the sole source of Canadians' rights against the state. In particular, the common law also affords protections of individual liberty. Nor is the scope of common law rights dependent on whether such rights are also entrenched in the Charter. While this follows as a matter of logic, Section 26 of the Charter itself affirms that the guarantee in this Charter of certain rights and freedoms shall not be construed as denying the existence of any other rights or freedoms that exist in Canada. This legal backdrop brings us to CPR and its elaboration on the common law rule in the form of a two-part test for showing constructive taking. 1. An acquisition of a beneficial interest in the property or flowing from it. And 2. Removal of all reasonable uses of the property. The issues present in this appeal require us to consider the meaning of a beneficial interest in the property or flowing from it under the first part of the test. In bringing greater clarity to this aspect of the CPR test, we do not change the doctrine of constructive takings, but simply apply it to the facts of the present dispute. As we will explain, the court in CPR did not use beneficial interest in the technical sense that it carries in the domain of equity. Rather, a beneficial interest is to be more broadly understood as an advantage. Hence the court's coupling of beneficial interest with the phrase, or flowing from the property. Clearly, if the interest acquired by the state can be one which flows from the property, what must be shown by the property owner can fall short of an actual acquisition by the state. Thank you.